how fast would that take? How long would it take for that to go into effect?
So if everyone heard the question, first, we don't think it's going to happen, but if it does, what's the timing? So we think it will take about a year and a half for it to happen completely, for a few reasons. One is, hey, if you hate pot, if you think this thing is illegal and you want it off the streets, the dumbest thing in the world would be to go to the Colorado Marijuana Enforcement Division and say, stop everything you're doing now. Because then immediately the seed-to-sale tracking system is unhooked and there's 1,000 tons of pot floating all of a sudden onto the black market. It does the exact opposite of what the antis want. That's one, is there needs to be ramped down to deal with the stuff itself. Second is the taxes. The biggest political opposition to changing the enforcement policy is the jurisdictions with Republicans and Democrats. It is more than half the states now that have some form of legalized marijuana, and the tax revenues. When we were in Denver, we wouldn't have been able to balance our budget during the recession without the revenues we were getting from marijuana taxes, and that was not a special tax, that was just the regular sales tax. That will take about a year and a half to ramp down, because if it's going to stop, you need to build that into the budget today for the following fiscal year, and that takes a full year and a half. The only time we know of federal enforcement for state legal marijuana businesses was back in 2012, when the federal government, the U.S. Attorney's Office, U.S. Attorney General's Office made the decision, hey, we want to shut them down if they're within 1,000 feet of a school. Right? It was based on the Reagan era sentencing, doubling those guidelines, and so they didn't kick indoors, they didn't go arrest people, they simply sent letters, and that was it, and everything worked. Does that answer your question?
Yes, thank you.
So it's federally legal, but the state says it is legal. Federal law trumps. It is the supremacy clause in the U.S. Constitution, and as we like to say, that was affirmed with finality with the Civil War. So federal law trumps, but they're not enforcing it, and so that's where we are today. People sometimes complain about what the Marijuana Enforcement Division is doing. Oh, are they jerks on this? Are they harping down? And no, their major purpose is to keep the industry alive. The way they gear things is, hey, if we follow the federal guidelines, then we are protecting the industry. If we let things slip here, then it's an excuse for the federal government to come in. And they kind of have ownership of that. We're the capital of this thing, we're the first ones. So that's the big picture stuff.
So moving forward with that, obviously on the last ballot we had Proposition 300 that passes. If you guys want to go a little bit further into that, because obviously we're going a little bit down that path. John?
Yeah, sure. So Initiative 300 is just the term basically for the city of Denver. Last year, a voter approved measure that would allow social consumption, like pot clubs, sort of. But to understand where that is now, it's helpful to give a quick background of where we are today with legal marijuana. So in the year 2000, Colorado passed Amendment 20, which legalized medical marijuana. California had done it a couple years prior, but Colorado was one of the first states in the country to have legal medical marijuana. And then for about 8 to 10 years, things kind of were status quo. They were mostly caregivers growing marijuana for specific patients. So folks would have a medical ailment and they'd get marijuana directly from a caregiver. Then around 2008, 2009, especially in the city of Denver, a large-scale kind of commercial medical marijuana industry grew up, and that's why you saw dispensaries on every street corner on Colfax and Broadway. That was under the original medical marijuana system. So Denver created some local laws about how to deal with it. Then the state of Colorado came afterwards and created some state laws. So this was all a reaction to what was happening really out in the marketplace. And then, as most folks know, in 2012, Colorado passed Amendment 64, another kind of first of its kind in the country. And then recreational sales went into effect on January 1, 2014. It's kind of important to know that was the first of its kind in the world, really. So folks look at Amsterdam for a long time. You've been able to go into like a coffee house and purchase marijuana and then smoke it right at that location in Amsterdam. This was totally different. This is based kind of on a liquor licensing model like you guys are familiar with. So In liquor, you go to a liquor store, purchase your 6-pack of beer, and then take it home to go consume it with your friends or in some other private place. Same idea with the recreational marijuana system. Go into a recreational marijuana store, buy your joints, products, or whatever, and then take them home for your own consumption. You don't consume it on site, which is opposite like what you guys do at restaurants where folks, if you have a liquor license to drink alcohol on premises, this was a whole new ballgame. So as Tom mentioned before, this recreational system came into place. The only way you guys would have these bags is if you guys all had medical marijuana cards and you were registered patients with the state of Colorado. So this is pretty wild from a legal perspective. It's all moving pretty quickly. So then fast forward to Initiative 300, which is the social consumption law. For a couple of years, well, for a long time, folks throughout the state have thought about pot clubs, because a big issue is, like I mentioned, you can go to a recreational store, purchase marijuana, but then where are you going to consume it? So especially if you're a tourist or you're visiting friends or whatever, you don't live here, you don't have your own house to go to. Keep in mind too, really the only, and we'll talk about private events, but in the legal sense, the only really clear way to use weed public or legally in Colorado is at your own home that you own. Because if you're in a rental, there's probably some language about not doing illegal stuff on the property, maybe not smoking, and it might not be about marijuana specifically, but cigarette smoke, marijuana smoke might bother other folks in an HOA or an apartment complex. So the issue came up of how do we kind of facilitate this industry? Where do folks go if they want to consume marijuana if maybe they don't want to do it in their own home? Maybe their kids aren't cool with it, their spouse isn't okay with it, and especially if they're tourists, they basically have nowhere else to go. So they were doing it in hotels. There was issues about, and there still are folks like walking down the 16th Street Mall smoking, which is not legal. You know, even though we're in Colorado, it's the same idea actually as, you guys would be familiar with open containers, taking like alcohol off the licensed premises of a liquor license, the same idea. You can't walk around in public with an open beer. You can't walk around on the 16th Street Mall smoking a joint. So Initiative 300 was a measure, like I mentioned, not put forward by the city government, but by the residents, the voters of the city of Denver. That passed last year, which basically said we want to create a special license to have places where people can consume marijuana in otherwise public places. So the real initial goal was probably to have it at bars and restaurants, like on back patios. So you still can't smoke indoors because you've got the Colorado Clean Indoor Air Act that prohibits cigarette smoking. In your guys' establishment, same thing applies to marijuana. So one of the original ideas was to have like back patio marijuana smoking. That law passed in the fall with the city of Denver. Then big thing for you guys to know, which you probably already do, the Colorado Liquor Enforcement Division, which regulates you guys, promulgated a rule which basically says no marijuana consumption on a liquor licensed premises. Doesn't matter how you're doing it. Smoking, edibles, vaping, can't do it. So that was kind of a twist on what the city of Denver was looking at doing with social consumption. So where it lands today, that process is still going forward. The department that Tom ran and that I work for is called the Excise and Licenses Department of the City of Denver. They're the ones that are tasked with putting out this license, the social consumption license. So they're currently working on rules and an application process for getting that up and running. It's basically going to be available to places without a liquor license. So coffee shops, like yoga studios, any other type of place that folks might want to gather and they want to smoke outdoors, but on this business location. So we're seeing how that's going to develop as we speak.
And nothing on that is like you couldn't go in there and actually take the product away from that location. It has to stay in there no matter what. There's no.
And they can't sell. It is about consumption. It's not about sales. You have to bring your own.
Okay. Do you see any of that evolving 300 at all? Would that be something that down the road that can expand, maybe potentially including alcohol? I know that's a very touchy situation, especially with restaurant owners, of having both marijuana as well as alcohol in the same location.
So there are a couple places where it can expand laterally and vertically. Laterally would be if there was a change to the legislature so that it was statewide instead of just Denver. As John said, right now it's just a Denver law, again going through the rulemaking. The other is that it is currently a rule from the State Liquor Enforcement Division that says no pot on liquor licensed premises. Can't have it in a restaurant, can't have it in a tavern, bar. That's something they could change. They could amend the law statute next year that can say yes on a patio, that they would allow on-site consumption.
Okay. When medical went through, obviously we saw, dispensary after dispensary down many roads, but with 300, do you have a sense of a lot of applicants coming through that this is actually going to be something that we're going to see quite a bit of these pot clubs?
No. Because of the ruling from Liquor Enforcement Division, and we kept getting asked this during the campaign, and from our clients, and we kept saying, no, liquor enforcement isn't going to allow this. It is, there are other things, it's going to be, as John said, the yoga shop or an event venue that doesn't have a liquor license. It can be, where you get your nails done, something like that. But it won't be big because it's limited. And so as soon as liquor enforcement gave that ruling, then it affirmed that this is going to be fairly small. There's also, and John, why don't you talk about this, the restrictions from neighbors. There's more power vested in the folks around someone who is applying than for anything else. Anyone, you all have liquor licenses, you know what neighbors can influence, how they can stand up for that needs and desires hearing. It's even more embedded and more empowered here.
Yeah, that'll be interesting. So some of the things that, and if you followed it all, the initiative was basically run by marijuana advocates. I think it's fair to say, I'd be interested to hear your thoughts, how the restaurant industry would you utilize it? Would you want, smoking in your back patio of marijuana or not? But so in order to get that law passed, they built in a lot of neighborhood kind of friendly requirements. So you need to get the consent of a registered neighborhood organization if you want to get this license, which is something that happens a lot in liquor licensing. If you're opening up a new place, you've got to go to a public hearing in the city of Denver at least, and so you gear up for public support. So you've got to get that. You do have to go to a public hearing to get this social consumption license. So anyone who does want to apply for it is going to go through a really similar hearing process to a new liquor license application. And just to your point too, I'd love to hear your guys' thoughts. Also, there are some folks who do want this in the restaurant industry, so there's some creative approaches that I think folks are going to come up with. So, you've got your liquor license premises, maybe right now it includes your back patio. What if you modify your premises so that is no longer part of your liquor license? Can you have folks go out there and smoke marijuana because it's actually not part of your bar or restaurant anymore?
And I was just about to ask about that exact scenario. Is it possible that you could have a consumption license and a liquor license and not apply them on the same day? Say if you had a private space like a back patio, could you say we are not going to serve alcohol tonight?
So that's a temporary modification of premises. So the norm for a temporary modification of premises for your liquor license is St. Patty's Day is coming up. We have the parking lot in the back, and we are temporarily going to expand our liquor license premises to include the parking lot. We're going to put up a tent, and after the weekend, we're going to take it down. It expands, and then it retracts. During that time, the parking lot is a liquor license premises. Can you do a temporary modification to shrink it to allow your patio to have consumption? In theory, yes. We don't know what the Liquor Enforcement Division is going to do.
Okay.
With what John was just saying, there's a good news, bad news part of this. The bad news for advocates is we really don't think there's going to be an opening of the floodgates with these social consumption clubs, just because of all the reasons John said. The flip side is there aren't going to be any horror stories. That this is going to have, in essence, a soft opening. It's going to be normal, and that bodes well. The good news then is for changes down the road, vertical or horizontal expansion.
So,
can you guys differentiate between, because I think it's confusing, public and private? Because these guys are doing events that are private and ticketed,
Yes.
I assume. And you're talking about under 300 public consumption.
So this is very confusing, and that's really important, and we'll get into that when we talk about some of the specifics. But public consumption of marijuana is not allowed, but public consumption is not defined. And it is confusing, and there's so many different analogous definitions. I'm allowed to do anything I want in the privacy of my own home. I can drink there, but wait, can I drink on the porch? I can't drink on the sidewalk or walk down the street. But if I am in my own home and I've got a giant window, I can't do jumping jacks naked. They're, not even adults would want to see that. I live in lots of kids in my neighborhood. I can get arrested for what I'm doing in the privacy of my own home because that would be viewed as public. There is still no definition when they were dealing with the police and what they could do and probable cause if they saw legal marijuana through a car window. All of those things have been chopped through over and over and over again. The bottom line now is that any place that it doesn't have to be private property, it has to be publicly accessible. So this may be private property, but anyone in the public can walk in. I can walk into a bank lobby, I can walk into a restaurant that is publicly accessible, and so like the Colorado Indoor Air Quality Act, as John said, no smoking at all, those are the kinds of places that comes up. So you cannot consume marijuana in a public place. It's not just because this is a liquor licensed premises, it's because it's publicly accessible. And that's one of the things where there is confusion and lines haven't been drawn yet. But in general, there is the liquor analogy. It's what you do with the stuff. So if I'm serving alcohol at a restaurant for money, obviously I need a license. If I am if I invite folks over to a dinner party at my house and serve alcohol, I'm not charging anything. Of course, I've already bought it from the store, I'm serving it. But then the in-betweens are, what if we're a dinner club and we do dinners at different people's houses and there's a charge, not for the wine, but we're all pitching in. That will certainly be fine. But there are lines that you cross. If you have folks come to an event at a private home and you as a caterer are not bringing the marijuana because you haven't bought it and you're not the one who's distributing it, but the owner. Think of if you do a wine tasting at your house, right? You do the wine tasting, the sommelier may come, you're buying the wine from the sommelier and you're serving it to your friends, to your guests. They can pitch in for things, but they are technically buying the wine. It's not the sommelier who's serving it someplace without a license. I'm the host that's at my house. I'm the one who is serving it. So you cannot prepare the stuff elsewhere and bring it on site. You can only manufacture infused products like edibles at a licensed facility. You can't sell for it, and we can get into those details. But if it's a private home, if it's a private venue, not accessible to the public, then that's deemed private. If it is publicly accessible, at this point you can't do it.
But the public's paying beyond the private property, but they're actually paying a fee.
Yeah, so that's where, fast forward to if you are charged with whatever you're charged with, what's the judge going to say? And the judge is going to look at the totality of the circumstances. If I show up at the event and I got a beer ticket and I was served alcohol, but I'm really there for the charity, I'm there for the band, I paid my $20 for my ticket and the booze was just, kind of tangential to it, did they need a liquor license in order to sell me that ticket? I wasn't buying the beer, it was part of the ticket, and there are a lot of people that weren't drinking. Most likely the judge is going to say you're okay. Charities go through this all the time. Do we need a liquor license for our fundraiser, kind of thing. But if they're coming on and people are paying in and it's for the food, it's for the service, it's for the explanation, again, use the, you guys are in essence pot sommeliers, right? That you are, and it's part of the event, it's part of the entertainment, it's the education. When I go to my neighbor's backyard, we're getting a lesson, my wife and I, in wine. We fail every time, we've done it a dozen times, I have no taste whatsoever, it's all wasted on me, but we give our money to our neighbors, it goes to the PTA fundraiser, and it's all fine.
So David mentioned when we first started that he had to think about, would his liquor license be in jeopardy if he cooked for a pot dinner on private property? And it sounds like if he's not involved in the pot aspect and he's just producing food, that he's right, he's pretty safe. Is that true?
Yeah, don't have the pot on your licensed premises. If you're doing it in your licensed kitchen that's part of your restaurant license, your H&R, where your liquor license is, there can be no pot there whatsoever. But if you bring the ingredients or mostly prepared food on site and then with your guests, and John, jump in.